Well, in the Perry case, I took the view that those doctrinal developments were those that were set forth in the Romer decision and in the Lawrence decision in 2003. And the other courts that have dealt with this issue have also dealt with the Nelson case in much the same context. The most interesting of which was the decision in the First Circuit DOMA case written by Judge Michael Boudin, who maneuvered his way around Baker versus Nelson by providing that a law or administrative regulation which discriminates on the basis of gender identity is subject not to intermediate scrutiny, but rational basis plus, carving out a fourth level of scrutiny. Exactly how far that is going to go, I'm not sure at this point. But it is clear, increasingly, as you've watched these cases unfold, that the justification for maintaining a gender identification in the estate of marriage is more and more states have enacted civil union laws, and as gays and lesbians have been raising children of their own and by adoption, these matters have assumed a much less importance. The subsequent justification that emerged that purported to be consistent with these trends, but essentially labeling gay and lesbian relationships as secondary or less worthy than heterosexual relationships, is of course the argument that marriage is for opposite-sex people, but we provide the same rights as marriage, but we call it by something else. We call it a civil union or domestic partnership. That was the argument that has been used to deal with the suggestion, which of course is made, that in fact the limitation on affording the marriage right to gay and lesbian people is essentially an act of homophobia. That argument played a substantial role in the Proposition 8 campaign. Among the exhibits that were played in that case from the campaign was a television advertisement in which a little girl comes into her mother's room and says, "Mommy, Mommy, my teacher says I can marry a princess instead of a prince." That is, the look on the mother's face as this little girl makes that statement, of course, indicates a level of distaste that is communicated without words to the listener. Well, the main justification, notwithstanding these justifications that were asserted in the campaign, the main justification during the campaign was laid on the notion that Proposition 8 was necessary to protect children and families, overlooking the fact, of course, that gay and lesbian people are raising children in California and that California public policy does not discriminate against such family units. And so I expected, with this background, when the Perry case came up, that the proponents of that initiative, those who were supporting Proposition 8, would present a series of witnesses who would present a justification for this limitation. I expected that there would be some testimony by some sociologists, by some historians, perhaps by some religious leaders, and certainly by the proponents of the initiative themselves. None of that happened. None of the proponents testified voluntarily. The only proponent who did testify was called by the other side. The witnesses that had been identified in the pretrial disclosures who had academic credentials withdrew and did not testify after having been deposed by David Boyce. And the only individual who did testify did not have who testified on the merits, did not have academic credentials, and I think it's fair to say that his testimony was problematic at best. It's an individual by the name of David Blankenhorn, who suddenly and subsequently has had a revelation and now supports marriage equality. So at the trial of this case, the justification that emerged for the limitation of the right to marry to persons of opposite genders was that the prohibition of same-sex marriage was necessary to encourage responsible procreation, necessary to increase the likelihood that children would be raised in stable households of married mothers and fathers. And that is necessary, it is said, because only opposite-sex couples can unintentionally bring children into the world. Same-sex couples definitely cannot do so. So it is particularly interesting that in this view, it would appear it is not gays and lesbians that are the threat to society, that society needs to be protected from all of these procreating heterosexuals. At the trial itself, the high point in my recollection of it was a cross-examination that David Boyce did, not of this individual Blankenhorn that I mentioned, but of the other witness that the proponents called who spoke on the levels of scrutiny. He was a political science professor at Claremont McKenna College. Well, 5 or 6 or 7 years before this was the first time that I had met David Boyce, long before Proposition 8 was ever on the horizon, long before anybody had any idea that this would come down the pike. We had invited David to come to a Northern District of California bench bar conference as the keynote speaker. I was chief judge at the time, and he and I were seated next to one another, just getting acquainted. And he spoke about his children. And I said, well, what are the ages of these children? And he gave some range that was huge. I don't remember exactly what it was, but it was something like 14 and 42. And I said, well, gee, David, that sounds like a couple of marriages. 3, he said. So, cross-examining this political science expert, David was going through public polling data with respect to the political power of gays and lesbians, and that is whether or not they have political power which will enable them to resist discriminatory enactments. And of course, part of that is how these individuals and how this group is regarded in society. So he was going through public polling data with respect to groups in society and whether they're well regarded or not. And he started at the top, the most highly regarded group. And he started from there, the top, and then the second, and then the third, one by one by one by one. Finally, he came to the second to the bottom, gays and lesbians. Then he said, now, Professor, what group in society is regarded less well than gays and lesbians? To which the answer was, people who've been married 3 or more times. Well, it is, of course, true that apart from uninformed and unintelligent bias and prejudice, it seems to me the resistance to marriage equality really stems from 2 sources. One of which is the traditionalism of the kind that I spoke of Judge Kelleher. It was just something that wasn't on the radar screen, something that people never really thought about, hadn't dealt with, and it just didn't seem to fit the pattern of what they expected. And obviously, as with someone intelligent and good-hearted as Judge Kelleher, who had not thought about female law clerks and so forth, when the prospect seemed imminent, it was no problem at all in getting his mind around that concept. And the same is true of so many people who have traditionally thought of marriage as simply a gendered institution. And basically for those folks, what it simply takes is a little exposure to marriage equality, to the fact that a marriage between gay men or lesbian women is really not any different from the marriage between opposite-sex individuals, that the same stresses and strains and issues involved in a relationship apply. And so that is the relatively easy source of resistance that can, I think, be overcome in time. But the second and more troubling source of resistance are social attitudes that find their justification in what are, at bottom, religious doctrines, at least as espoused in the majority of religious denominations, if not, of course, in the adherence to most of those denominations. And you may have noticed over the weekend a full-page ad in the New York Times by the Reverend Billy Graham, in which he, without mentioning any candidate by name, nevertheless stressed the importance of the election that we face in about 8 days, and the necessity for the voters to bear in mind the need to maintain the biblical definition of marriage. And that makes this issue difficult because there are plainly millions of Americans who are profoundly religious in one sense or the other, and who are nonetheless good-hearted individuals, but who nevertheless feel that they cannot square the notion of marriage equality with their religious convictions. That makes the challenge, it seems to me, for lawyers and judges a somewhat daunting one. It is daunting in the sense that moral values are a part of any legal institution, but in our society, those moral values have to be expressed, in my view, in a way that is, if not divorced from religious convictions, nevertheless finds their rationale and their support in some ground other than these religious beliefs. And it is part of the responsibility of judges in making decisions in this area, I think, to confront the source of this attitude, and yet at the same time to deal with it as sensitively and as ably as possible. To essentially make the case that our laws in this multicultural society and in an increasingly heterogeneous world, a world in which people come from all sorts of points of view, it is important for judges in dealing with these kinds of issues to strongly make the case that in a society that deals with people from disparate backgrounds, it is important that our civil life must be based upon secular values rather than religious values, that our civil laws must be free of the dogmas and doctrines of theology. Chief Judge Jacobs put it rather well at the end of the Windsor case, in which he pointed out quite succinctly that the case that was before the Second Circuit was not a case that involved holy matrimony. It was a case that involved civil matrimony. And he pointed out, if you want holy matrimony, you should go next door, presumably to the church near the federal courthouse in New York. This is a difficult task for lawyers and judges to deal with because, obviously, of the deeply held and sincere religious convictions of so many of our citizens. And yet, I think we need to confront the reality that much of the resistance to marriage equality comes from these convictions that have a source that's very deep in the hearts and minds of millions and millions of our citizens. So our challenge as lawyers and judges, it seems to me, is to deal with that. I don't think we have any choice, and I have no doubt that in due course the result will be marriage equality, but much is going to depend upon how we deal with the attitude of so many of our citizens that really finds their foundation in religious beliefs and convictions. But after all, it's no fun being a lawyer or a judge unless you have a challenge now and again. Thank you very much.